So I'd like to introduce our speakers who will share their perspective on homeschooling in Oregon. As I mentioned, after I do that, I'll talk a little bit about the legal framework and then turn it over to you. So Carol Kenobi is Assistant Superintendent of the Lane Education Service District. Prior to her current role at Lane ESD, she served as Special Education Director and Program Administrator there, and she began her education career as a special ed teacher. She earned her master's degree in special education from the University of Oregon.
Go Ducks.
And she serves on the board of directors for McKenzie Personnel Systems and Direction Services, both nonprofits serving individuals with disabilities. Ann Beam homeschools her 3 young daughters, currently in 2nd grade, kindergarten, and preschool, and she started homeschooling about 1.5 years ago. She has a bachelor's degree in Christian counseling from Eugene Bible College and a master's degree in mental health counseling from Walden University. She spent 5 years working with emotionally disturbed children at Jasper Mountain Center and currently works part-time as a church counselor. So thank you both so much for being with us today. So I'm going to get started by talking a little bit about the legal framework for considering homeschooling. First, about some of the constitutional protections for homeschooling, and then about how states regulate homeschooling. I think homeschooling is an especially interesting topic to discuss because it really highlights some of the potential conflicts between the parents' interests in determining how their children are educated, and then the state's interests in both regulating education and also in protecting children from harm. Homeschooling is becoming increasingly popular. The National Center for Education Statistics estimated in 2007 that 1.5 million children were being homeschooled nationally, and that number has been steadily increasing for almost 10 years. And the same study reported that most parents said the primary reason they homeschool is to provide religious or moral instruction to their children. In fact, 83% of parents identified that as one reason that they homeschool. The next 2 most important reasons were concern about the school environment, including safety, drugs, or negative peer pressure, and dissatisfaction with academic instruction in schools. The Supreme Court has not expressly addressed whether there's a constitutionally protected interest in homeschooling, but it has addressed claims of parental rights to control their children's education and, of course, religious freedom claims. So I'll talk a little bit about those. The Supreme Court first recognized parents' right to make basic decisions about their children's upbringing in a pair of cases from the 1920s, Meyer v. Nebraska and Pierce v. Society of Sisters. Meyer v. Nebraska was a 1923 case where the court held unconstitutional a state law that prohibited teachers in public and private schools from teaching in any language other than in English. And the court used a substantive due process analysis and struck down the statute as an unconstitutional infringement on the right of parents to direct their children's upbringing. In so doing, it added to the list of substantive due process rights the right to marry, establish a home, and bring up children. Pierce v. Society of Sisters was decided 2 years later, and it reconfirmed the parental right. Pierce concerned an Oregon statute that required that all children attend public as opposed to private school. The petitioners in that case were a Catholic parochial school and a private military school, and they alleged that the statute violated, among other things, parents' rights to control their children's education. And indeed, the court decided the case as a parental rights case, holding that under Meyer v. Nebraska, the statute unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of children under their control. The countervailing state interest in both Meyer and Pierce was the state's interest in sort of promoting civic development among its citizens, and doing so by regulating children's education. And the court noted in Pierce that it would uphold a state's reasonable regulation of schools as a means of achieving those interests, but it held that the state's interest in civic development didn't have a reasonable relation to the ban on private schools. And it concluded, the child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. So far we have 2 cases upholding parental rights claims in the context of education. The first case where the state's interest prevailed over a claim of parental rights was Prince v. Massachusetts, which is a 1944 case that, although not strictly about control over education, certainly influences this discussion. And Prince, the aunt and custodian of a 9-year-old girl, was convicted of violating child labor laws by letting the child hand out Jehovah's Witness magazines on the street. And the child's custodian claimed that the law violated her right to freedom of religion and also her parental rights. The state, in turn, claimed interest in safeguarding children from abuse and in giving them opportunities for growth into free and independent adults. And the court declined to apply strict scrutiny in evaluating those interests, noting instead, the mere fact that a state could not wholly prohibit this form of adult activity does not mean it cannot do so with children. So it upheld the law as a means of protecting children from essentially the dangers of the street, and concluded, in language that's been quoted in many other opinions, parents may be free to become martyrs themselves, but it does not follow they are free in identical circumstances to make martyrs of their children. And then in Wisconsin v. Yoder, which was decided almost 30 years later in 1972, we have the only Supreme Court case that addresses a fact pattern similar to homeschooling. In that case, Amish parents challenged a Wisconsin statute that required parents to send their children to school until the age of 16. The plaintiffs in this case were Old Order Amish who believed that salvation required life in a church community separate and apart from the world and its influences, so that requiring their children to attend school would substantially interfere with their religious development. And the court, finding the plaintiffs' objections were firmly rooted in religious belief, applied strict scrutiny and granted them an exemption from the compulsory attendance law, relying not solely on the parental rights claim, but also on the free exercise clause of the First Amendment. But in granting the exemption, the court really emphasized that the Amish community is what it called a highly successful social unit apart from the conventional mainstream, and that there was no evidence that Amish children grew up to leave the community and then become burdens on society. So subsequent lower court and state court decisions have interpreted Yoder in various ways. Some state courts have interpreted it to support a constitutional right to homeschool, most often when the parent's motivation for doing so is religious. But more commonly, courts have distinguished Yoder by emphasizing that the Amish plaintiffs there didn't intend to reintegrate their children back into society. So for example, in a Seventh Circuit case, Duro v. District Attorney, the court upheld a North Carolina compulsory attendance law that did not allow homeschooling, even though the parent had a sincere religious belief, finding that the state's interest in education overrode the parent's interests. And the court distinguished Yoder, noting that the Amish are a community that has existed separately for centuries and did not plan to reintegrate their children into the mainstream communities. But this kind of debate hasn't reached the Supreme Court, probably because today all states allow homeschooling, either by specific statutory provision or by state court decisions that interpret statutes regarding private schools to include a homeschooling option. I do want to mention one other possible state interest in regulating or even prohibiting homeschooling. The kind of state interest that the court considered in Meyer, Pearson, Yoder were things like promoting civic development and helping children become self-reliant, self-sufficient members of society. But more recently, we've seen an interest cited in Prince, protecting children from harm, come up again. So in a 2008 decision, Jonathan L. v. Superior Court, the California Court of Appeals, held that a state's statutory permission to homeschool can be constitutionally overridden to protect children's safety in some circumstances. The family and Jonathan L. had a history of dependency court proceedings involving charges of physical abuse, neglect, and failure to prevent sexual abuse of the children. And two of the youngest children have been declared dependent because of the abuse and neglect of their older siblings. So the children's attorney sought an order seeking that the children be required to attend private or public school instead of being homeschooled by their mother, so that they would come into contact with mandatory reporters. And the court recognized the parents' due process interest in directing the upbringing of their children, but held that the state's interest in protecting the child's safety could constitutionally override that interest. So it remanded for the trial court to consider whether the safety of the children justified doing so in this circumstance. As I mentioned, all states allow homeschooling at this point, but they regulate it in really different ways. So at the very low end of regulation, 10 states impose no regulations whatsoever, not even a requirement that parents notify schools that their children are being homeschooled. 14 states require only that parents notify a school district that they are homeschooling children with no additional regulations. Oregon and 19 other states, plus the District of Columbia, require that parents notify a school district that they're homeschooling, and they also require either standardized test scores or some form of professional evaluation of students. So Oregon requires that parents notify the state within 10 days of removing a child from school, and then it requires testing at grades 3, 5, 8, and 10. But even those requirements aren't very strict, so children must only score above the 15th percentile. If the child doesn't score above that percentile, they retake the test the following year, and then if there's a continued decline in score, there can be some state intervention. The highest level of regulation, which 6 states impose, requires notice, test scores, or evaluation, plus an additional requirement. So it could be something like curriculum approval, teacher qualifications, or even visitation by state officials. And of course, there are some good arguments against regulation. For one, Curriculum requirements can require parents to teach the very subjects they wanted to avoid in public schools, right, and prevent them from teaching the things they want to teach. And of course, teacher qualifications exclude a lot of parents. But there are also some good arguments for increased regulation. A really obvious one is that the quality of homeschooling is totally dependent on the parents' commitment, abilities, and things like that. So children of parents like Anne will really come out ahead, but of course that depends on the quality of home education, and without control over curriculum, it's impossible to ensure children are getting the basic education. There's also the interest in preventing harm to children, even beyond cases of known abuse, like in Jonathan L. So, at least in theory, one of the state's roles in education can be to protect children from harm. Homeschooling here, of course, is not the problem, but like any form of isolation, it can be used as a tool by parents who want to abuse children. And we've seen some cases in Oregon, like the Angela McAnulty case, where a parent starved her child to death. She was her teenage daughter, which seems amazing that no one noticed, but in part, the child was homeschooled, so she wasn't coming into contact with the outside world. That is, of course, a really extreme example, and it's not a typical situation. Certainly not the situation with good parents, but it's just one example of why regulation can possibly matter. A practical issue we see resulting from limiting regulation is that homeschool children may be unprepared for college. So for example, the University of California system reviews syllabi of high school courses and required subjects, and applicants can only count courses that the system approves toward required high school prerequisites. And the university system rejected some conservative Christian texts, including some popular homeschooling texts, and a group of Christian schools sued, claiming violations of free speech, religion clauses, and equal protection. The district court there granted summary judgment for the university systems, and the Ninth Circuit in a 2010 case affirmed, finding the policy was reasonable and did not involve viewpoint discrimination. Some commentators also argue that failure to regulate might violate state constitutional guarantees to an adequate education, especially where homeschooling parents adhere to the belief that girls don't require as much education as boys. So just some interest to consider.